May it please the Court. My name is Vincent Tubiano, and this is my partner, David Hutchison, and we're on behalf of the appellant, Robert Dolan. To please the Court, I'd like to reserve a couple minutes at the end for rebuttal. As the Court can tell from the style of the case, this was a dissolution of marriage action, and
well, we can tell from more than that. We've read the briefs.
The Court's no stranger to this particular case. In short, the husband filed a second petition to modify judgment with respect to child support on the basis that he was suffering financial problems. And what he did is in March of 2009, he files that, and this is where the case essentially starts to begin. The former wife was personally served with a copy of that motion in court. Approximately 6 months later, in September, she goes ahead and files a pro se motion to dismiss for failure to state a claim. The wife, throughout the course of litigation, alternated between sometimes appearing pro se and sometimes being represented by counsel. Approximately a year later, she is represented by counsel, and counsel files a motion to dismiss with respect to ineffective service of process. And where everything starts, essentially, is this November 5th, 2010 hearing before the lower court. The lower court is listening to argument of counsel, is attempting to kind of fix what's going on with respect to this particular case. The court goes ahead and agrees with the counsel for the husband that the former wife...
I'd like to step this back just a moment. On the first motion to dismiss that was filed pro se,
correct.
What was the disposition of that motion? I know you referred to it, I think, in the brief as denied, as the motion to dismiss was denied. My reading is that it may have been stricken, but what was the actual disposition of the first motion to dismiss? Do you know?
Your Honor, I don't know. I believe that the trial court may have simply denied it as being abandoned, but we don't really know.
Well, but the motion to dismiss that she filed in 2009 is strictly based on a failure to state a cause of action.
Correct. And
she did not raise the issue of service of process.
At all.
But it was disposed of at some point?
I believe so. Yes, Your Honor. And as the court correctly indicates, it doesn't raise whatsoever the issue of failing to state a claim. So what the court does is the court essentially agrees with counsel at the hearing, and as the trial court is attempting to reason through this, indicates that she agrees with the argument raised by counsel. Now, at that time, counsel wants to make an or tennis motion in which two men, he indicates, look, Judge, it's been a year, I would like to amend. And at that point, the judge, who is presumably tired of this case, indicates, good, fine, amend, 5 days. Counsel proffers, Judge, I'd like to go ahead and amend and reserve. It was at this point that the judge...
But it's clear if you're amending a complaint, you don't have to personally serve it then. I mean, that's basic law.
I would agree that you wouldn't have to do that. So,
what was the trial court's reasoning? I don't see it in the brief. Why the reservice?
The court didn't really provide a reasoning. The court was there attempting to hear argument on a subsequent motion to dismiss. The court just simply says, serve it personally in 5 days.
Well, let me ask you this, because just to get to the bottom point that I'm concerned about, and I have both sides. It appears to me that if the wife, whether pro se or with an attorney in 2009, files a motion to dismiss, fails to raise the issue of service of process, why did it even become an issue after that point? Because isn't it waived at that point?
I would agree, and that was the husband's entire argument at the November 5th hearing, which the court was inclined and agreed with, and essentially issued a subsequent order, a written order, that indicates that the order essentially is denied with respect to that, to the wife's motion to dismiss for failure to raise the service of process issue.
Right.
So, but in the body of that motion is when we have this 5-day personal service requirement. Counsel raises at that point to the trial court, Your Honor, can we go ahead and serve counsel? And the trial court says, not if they don't want to accept service. We indicate to the trial court that in the past we had a lot of problems serving the former wife. The trial court essentially ignores those types of concerns and says 5 days. We at that point employ a process server to go ahead and serve the former wife. We provide a fax correspondence to the wife's attorney asking if they would accept service of process. We don't hear a response.
And there are several attempts to try to serve her at her house and ask her work,
Correct.
which are unsuccessful, and there's an affidavit filed saying he believes that she's trying to evade service.
That's correct.
And you're asking to serve by publication and also asking for an extension of the 5 days. You don't get either
Correct.
issue heard by the trial.
Correct. What happens is we within this 5-day window, we file this motion, we set it for hearing in December, but former wife's counsel then simply sends a letter.
What I'm trying to say is that I think we're pretty aware of the facts, so you can just give us the argument if you want.
I didn't hear the
I think we've understood your argument.
We understand your argument, but I still go back to why are we even concerned? I mean, doesn't it end at the fact that the wife filed a motion to dismiss and failed to raise it a year prior? Doesn't it end there?
It does, and I referenced that in the beginning of the first issue in my initial brief. Yes, but I think what the reason that it took this strange twist was the Ortennis motion made by counsel for the husband.
I'm talking about from our viewpoint. Doesn't it end there?
Yes, I would agree that it would certainly end that it was an issue that was waived, and at that point, anything that the court did, amendment should just simply be by mail.
Thank you.
And,
Thank you, counsel.
May it please the court, my name is Daniel Kaplan. I represent the former wife, Kim Dolan.
Maybe you can shed light on why the court all of a sudden imposed, contrary to the rules of civil procedure, imposed a new requirement to serve personally within 5 days. Seems a very arbitrary thing to do.
I don't think it's in violation of the rules. I think the rule
allows service to counsel once the issue of service of process is dead, and now it's been dead for a year.
Number one, I don't think the issue of service of process was dead. I think the first motion to dismiss filed by Ms. Ferguson or Ms. Dolan in a pro se basis raised the lack of service. I don't believe that motion was ever disposed of.
Mr. Kaplan, I'm going to ask you, did you review this brief before it was submitted to the trial court? I know you didn't sign off on it, but did you either draft it or review it before it was submitted to this court? Because I'm very troubled by the brief itself.
The brief to this court?
To this court.
Yes, I did.
Well,
can I ask what you're troubled about?
Yes, I'm going to tell you, I think it mischaracterizes the evidence. The statement of facts is totally incomplete. The only facts that you state in your statement of facts are those that support your position. And as an officer of the court, that's not what you do with a statement of facts. You state all of the facts, whether they're supportive of your position or not. And I'm very troubled by some of the misrepresentations also within this brief. For example, you state that the former wife filed a motion to dismiss for lack of service of process on September 24th, 2010, and then you failed to mention that it was the second motion to dismiss, which, as Judge Flores is pointing out, is positive in this case. Because if you file a first motion to dismiss and you do not state a claim for service, for lack of service, personal service, you've waived it. If you litigate, if you do anything else, you've waived it. So the fact that this was her second motion to dismiss was clearly a very material issue in the statement of facts. Totally leave that out.
For some reason, I want to think that the first motion to dismiss that Judge Flores mentioned raised the issue of lack of service.
No, what I'm saying is in the brief, you don't even put that in the statement of facts to even argue it. Then, I think this is a material omission. You then fail to mention that when you filed your motion, and not only failed to mention in the brief, but failed to mention to the trial court when you asked for the motion to dismiss the complaint because of lack of personal service within the 5 days, as the trial court has ordered, that there is a pending motion for service by publication and for an extension of the 5 days because of an affidavit of the process server that says that he thinks that the former wife is trying to evade service. All of these facts are conveniently left out, and I'm very troubled by the present situation.
I think you might be mistaken as to some of the facts. I don't believe there was an affidavit of the process server.
It was in the motion. There was a verified motion. You're right, it's not an affidavit, but it's a verified motion that says that talks about the attempts made by the process server to try to serve at both her home and at her work, and that they believe that she's trying to evade service, asking for service by publication and asking for an extension. Instead, you go in by a letter to the trial court and say, 5 days are up, no service, please dismiss, without even alerting the trial court there's this pending motion.
Again, I think there might be some confusion as to the facts. Number one, November 5, the judge gave 5 days to serve. The process server did not start serving or even attempt to serve until the 4th day at 8:46 p.m. He did not try and serve my client at her
appointment. Was there a pending motion, a verified motion, pending before the trial court at the time you filed your motion to dismiss and got a dismissal from the trial court? Yes or no?
The answer is I don't know. I'm not sure if it got crossed in the mail. I honestly don't know. I would tell you if I did. But I think that the trial court has the power when there's been problems with receiving mail from the former husband's counsel's office to indicate or demand that certain things be personally served. And that was done, and any waiver of that was, or any issue with that was waived when Mr. Hutchinson himself agreed.
I have here the wife's motion to dismiss, and she does ramble on about the merits of the case, but I fail to see anything that addresses the service of process. It's the husband committed perjury, not entitled to the money, etc., etc. Just argues basically the merits of the case.
Okay.
Nothing about service.
Okay.
At that point, that's game, set, match.
Except I think a trial court has jurisdiction and the power to say this must be served.
Wait. How does the trial court have jurisdiction to say it must be served if it was served and there was a motion to dismiss and didn't raise it? And under the rules, says if you don't raise it, it's waived. How does the trial court then explain to me how the trial court gets around the rules of civil procedure to say, okay, even though it's been served, you filed a motion to dismiss, it's been waived, and now I'm going to require you to serve it?
Because I think if you read the rule, it says, unless otherwise ordered by the court.
No, counsel, I'm sorry. A motion making any of these defenses, referring to that, shall be made before pleading if a further pleading is permitted. Waiver of defenses is waived if it's not raised at that point. She filed a motion to dismiss, she didn't raise it. And the problem I've got is I don't see where it went on from that point. And what I'm asking you is do you have any case or anything you can give me to show me that, in fact, the court has jurisdiction to do what it did?
My recollection of the rule was that it is normally done by sending to counsel or sending by U.S. mail unless otherwise ordered by the court. And in this case, it was otherwise ordered by the court, and the former husband's counsel, volunteered to have it reserved at the hearing in November. Eventually, the transcript was received by us. It wasn't received when we did the initial brief, but eventually we got it. I had the judge's disposition notes when the brief was submitted. Right. And Mr. Hutchinson, I believe at page 7, says, I'll reserve it.
So your position is that there was a waiver of the waiver?
Yes. Okay. That is my position, and also my position is that this is not an issue that was raised before the lower court, and in order to raise something for this court, you first must give the trial court an opportunity. He never filed a motion for rehearing, he never filed a motion on that issue. So I think he's procedurally barred based on the cases that we recited in the brief, saying that you can't raise an issue for the first time on appeal.
Anything else?
No, sir.
Thank you, counsel.
Very brief.
With respect to failing to file a motion for a hearing, anytime that argument doesn't apply, Your Honors, anytime with respect to an issue of law. All the case law, whether it's Broadfoot or anything that's come out of this court and other appellate jurisdictions throughout the state, only require a motion for a hearing to be filed any time that there's a factual issue. And the policy reason is to give the court a second bite at the apple. In this particular case, no discovery.
Well, wouldn't a motion for rehearing have alerted the trial court that at the time the trial court granted the motion to dismiss, there was a pending motion that had not yet been ruled on by the trial court.
I don't think it would have made any difference in that particular
Well, how do you know? I mean, if the trial court perhaps had read the verified motion and heard from the process server as to what attempts were being made, perhaps the trial court either would have allowed service by publication or additional time to serve. How do you know?
Perhaps. No, I agree that perhaps that would have alerted the court. But with regard to waiving appellate right later, I don't believe that that a motion for a hearing is necessary when the issue on appeal has nothing to do with findings of fact at the lower court.
Thank you. Thank you, gentlemen.